Hey guys, welcome back to the channel. This is the House of Law and I'm Attorney Al Jumrani. By popular request, I am finally making a video on the Indeterminate Sentence Law or Act number 4103. I know there are a lot of videos out there explaining the ISL or ISLAW, but in this video, I will try to illustrate how to apply and compute the Indeterminate Sentence Law. Let's begin. Act number 4103 or the Indeterminate Sentence Law was passed by the Philippine legislature and approved on December 5, 1933. A very old law but still very applicable and very useful in criminal law and justice to this day. Now, what are the significant features of the law? Under Section 1, the ISL shall be applied to two types of offenses. First, offenses punishable under the revised penal code, and second, offenses punishable under special laws. Note, however, that under Section 2, the ISL does not apply to persons convicted of the following offenses. Offenses punished with death penalty or life imprisonment, treason, conspiracy or proposal to commit treason, misprision of treason, rebellion, sedition, or espionage, piracy, and offenses whose maximum term of imprisonment does not exceed 1 year. Now, also, the ISL does not apply to the following. First, habitual delinquents. Second, those who escaped from confinement or who evaded sentence. Third, those who have been granted conditional pardon and have violated the terms of conditional pardon. And lastly, those already sentenced by final judgment at the time of the approval of the Indeterminate Sentence Law. Accordingly, when the ISL is applicable and the crime is punishable by the revised penal code, the accused found guilty of the crime shall be meted an indeterminate sentence composed of a maximum term, which shall be what should be prescribed by the revised penal code, taking into consideration the attendant circumstances, and a minimum term which shall be within the range of the penalty next lower to that prescribed by the code for the offense. Now, if the crime is punishable by a special law, the accused found guilty of the crime shall be meted an indeterminate sentence composed of a maximum term not exceeding the maximum fixed by said law, and a minimum term which shall not be less than the minimum term prescribed by the special law. Now, you might be wondering, what are these maximum and minimum periods? And is there a medium period? Under the revised penal code, except for death and reclusion perpetua, which are imposed in their entirety, the other penalties prescribed are divisible into three periods. We have maximum period, medium period, and minimum period. These divisible penalties and their maximum, medium, and minimum periods are ta-da! Okay. There you can see it right on your screen. Now, the imposable penalty shall depend on the presence of either mitigating or aggravating circumstances. The rules are provided under Article 64 of the Revised Penal Code. But for purposes of brevity and simplicity, we can summarize it as follows. When there are no mitigating, no aggravating circumstances, impose the medium period. If there are mitigating circumstances but no aggravating circumstances, impose the minimum period. If there are aggravating circumstances but no mitigating circumstances, impose the maximum period. But if there are both mitigating and aggravating circumstances, then set them off against each other. So let's say there are 3 aggravating against 2 mitigating circumstances. That's 3 minus 2 equals 1 aggravating circumstance, then impose the maximum period. Or let's say there are 3 aggravating circumstances against 3 mitigating circumstances. So 3 minus 3 equals 0. So impose the medium period. Okay? All right. Now, let's try an example. Let's do homicide. So, for this exercise, what do we have to prepare? Well, first, prepare a paper, a pen, a highlighter, and a codigo of the penalties. Let's do this. Article 249 of the Revised Penal Code provides that the penalty for homicide is reclusion temporal, which has a duration of 12 years, 1 day to 20 years. Now, what I do when I compute the penalty applying the ISL is to plot the 3 periods in reverse, meaning the maximum on the top, the medium in the middle, and the minimum at the bottom. Now, know the next penalty lower in degree to reclusion temporal. Check your codigo. So the penalty next lower to reclusion temporal is prisión mayor, which has a duration of 6 years and 1 day to 12 years. So let's write that down. Prisión mayor. And the period is 6 years, 1 day to 12 years. Now, prisión mayor also has 3 periods. Let's plot them again in reverse. Maximum, medium, and minimum. Okay. So, we've already plotted both penalties. Now, what to do next? First, get the maximum penalty. Ang sabi ng Section 1, the maximum term shall be what is prescribed by the Revised Penal Code. So the maximum term shall be the appropriate period of reclusion temporal. So let's bracket the entire reclusion temporal. Second, check if there are aggravating or mitigating circumstances. Sabihin na nating may isang mitigating circumstance sa example natin, let's say voluntary surrender. So tulad ng sinabi ko kanina, kung may mitigating circumstance, the imposable penalty is the minimum period. So let's highlight the minimum period of reclusion temporal. Yan. Third, get the imposable minimum penalty which according to Section 1 of ISL shall be within the range of the penalty next lower to that prescribed by the code for the offense. So as earlier determined, the penalty next lower is prisión mayor. So let's bracket the entire prisión mayor. Now, unlike the maximum period which is determined properly according to attendant circumstances, there is no fixed standard for the minimum penalty. The court can choose to impose the minimum, medium, or the maximum period of the penalty next lower to that prescribed. So pwedeng maximum period ng prisión mayor or minimum period of prisión mayor. That's entirely up to the court. But take note that in one of the early cases interpreting the ISL, the case of People versus Docosin, decided December 14, 1933, the Supreme Court laid down the factors that should be considered in fixing the minimum period, namely, age of the accused, especially with reference to extreme youth or old age, his general health and physical condition, his mentality, heredity, and personal habits, his previous conduct, environment, and mode of life, and criminal record, if any, his previous education, both intellectual and moral, his proclivities and aptitudes for usefulness or injury to society, his demeanor during trial and his attitude with regard to the crime committed, the manner and circumstances in which the crime was committed, and lastly, the gravity of the offense. Note that the discretion is most of the time respected by the appellate courts. Ang importante, pasok sa penalty next lower ang pinili ng judge as minimum period. So back to the example. We need to choose the minimum period. Let's say in our example, aside from voluntary surrender, the court also is aware that the accused is already old. This can merit some mercy from the court, just like a mitigating circumstance. So the court can rightfully impose the minimum period of prisión mayor. So let's highlight now the minimum period of prisión mayor. Yan. Finally, let's do sentencing. Using your codigo, write down the specific days, months, or years of the periods we have highlighted. Okay, so since we chose the minimum period of reclusión temporal, let's check for the duration of the minimum period of reclusión temporal. Okay, so the minimum period of reclusión temporal is 12 years and 1 day to 14 years and 8 months. Okay? Okay, let's write that down. So that's 12 years, 1 day to 14 years and 8 months. Okay. That's the minimum period of reclusión temporal, which will now be the maximum period of the imposable penalty. So meanwhile, the duration of the minimum period of prisión mayor is 6 years and 1 day to 8 years. So let's write that down. 6 years, 1 day to 8 years. All right. So now let's do the sentencing based on what we have already computed. Kunyari, ako si judge. Will the accused please rise? Mr. Juan de la Cruz, you have been found guilty of the crime of homicide and is hereby sentenced to suffer an indeterminate penalty of 6 years and 1 day of prisión mayor as minimum and up to 14 years and 8 months of reclusión temporal as maximum. So ordered. So, ganun lang kadali ang computation ng ISL. The purpose of the ISL is for the accused to have an earlier chance of getting parole. So, instead of serving the minimum penalty prescribed, pwede na siya mag-parole if he can serve the appropriate period of the penalty next lower, as may be computed using the ISL. So, that's it. I hope naintindihan nyo na ang ISL. If you found this video helpful, please hit the like button. Please subscribe to my channel if you haven't subscribed yet. And please click that notification bell to be alerted in case I upload a new video. Till next time, laging tatandaan, isip ay buksan, alamin ang batas.